Well, friends, good afternoon or good evening already. Yes. I'll try to be, of course, brief. I was given a mandate, or I gave myself a mandate to speak to you about recent development in maritime casualty law. Initially, it was more about the Ever Given, which I will dedicate some good amount of time to. But I thought that it would also be interesting to relate to more of the developments concerning, the casualties in general, which is, I guess, a wet area of shipping. So what I would like to do is just to take you through this. Is this, yeah? Yeah. So I'll talk a bit about the Ever Given, of course, some developments concerning salvage law, collision, sustainability, as a conclusion. So in terms of the Ever Given, we had a moment for those of us who attended at Split, the magnificent maritime law conference organized by Petra. I had the chance to comment a bit about the Ever Given developments. Just before the Split conference, a judgment was handed down by the High Court of England on the matter, and this involved a salvage claim by the salvors, represented by Smith International, which is one of the big players in salvage. So Smith Salvage brought a claim against the ship owners and the ship operators. If you recall, the Ever Given, actually, just to give you a quick recap of what happened, the Ever Given in March 2021 was sailing northbound through the Suez Canal and accidentally ran aground, eventually blocking the passageway for a few days, 6 days, I think, all in all. Basically, that brought to a halt international shipping, because the Suez, of course, is a major seaway for east-west transport. The Suez Canal imposes the use of local pilots to all transiting vessels, including the Ever Given, which is a huge container ship, one of the largest container ships in the world. So these pilots were effectively used because it was mandated by Egyptian law. But unfortunately, notwithstanding the use of the pilots, and because there was a sandstorm with a very high, a grave grade of a sandstorm, the ship wasn't maneuvered well, and it ended up tilting sideways across the channel, or across the Suez Canal, and it ended up touching ground, and it wouldn't move. So the Suez Canal Authority sent out some vessels, tugs, to help the ship get off the sands, but it was considered necessary that the vessel should retain anyway the services of a salvor, and the salvor was contracted and that was Smith International, which is a Dutch company specialized in providing international salvage services. Now, interestingly, all of this, as I said, March 21 is when the ship ran aground. March 29 is when the ship was actually effectively refloated. So it was a matter of a few days when the ship was actually blocking the canal. So usually in those circumstances, even before it was understood that this was major world headlines, because the whole world was talking about it, all the global supply chains were affected. Initially the ship owners, the insurers, the ship operators were in negotiation with Smith International in Holland, and they were also obviously dealing with the local Egyptian authorities, and that wasn't necessarily all that easy, of course, because of some idiosyncrasies, I think, involving Egyptian authorities. But whatever that may be, you would imagine that a contract would have been settled between the ship owners on the one hand and Smith International for the refloating operation. So 2 years afterwards, the case was decided on a preliminary basis by the High Court of England, and the question for determination at that stage of the proceedings was whether Smith International could actually bring a claim not on a contract but in salvage, salvage law, which is basically it's a Pandora's box usually, or a treasure box for claimants, because in salvage you can, as a claimant, usually as a salvor, you can claim for not just expenses, but also a reward, a profit. That's what salvage law allows. But in order to do that, you have to be sure that you don't have a contract. And we have an expert on salvage who will comment later if need be, if I say anything wrong. So the court had to decide, had to determine this preliminary question, whether there was actually a contract, because in those few days while the ship was aground, and efforts were frantically being exerted to get the ship back afloat. There was a discussion of contractual terms between the parties, by emails, by WhatsApp, by phone calls. And all of this is documented in the court case. In addition to the actual judgment, we also have an appendix, which was the agreed kind of statement of facts between the claimant, or the plaintiffs, that is the salvors and the ship owners. So they agreed on what communications were made. And obviously this wasn't a matter for a lot of controversy, because all they had to do was to copy paste the written messages that were exchanged, whether by email or WhatsApp. And it's a very a tedious matter, but it just tedious matter to go through that appendix of the communications, but it's a beautiful, really, I think, exercise of seeing how companies work in our business, in the maritime business. And you could see also how much the, of course, the owners who were in Japan were actually very much concerned about not I would say, I know I'm being recorded, not so much getting the vessel afloat, but reducing their financial exposure to the costs of the operations. I mean, it's almost it's a scandal in itself. If you go through the exchange, they were kind of delaying. I mean, that's my take on the exchanges. It was they were actually buying time to get the Smiths, the salvors, who are already engaged and deploying mobilizing their people, mobilizing their equipment. They were delaying agreement because they didn't want to agree to more the higher cost necessarily. So, as I said, going back to the judgment, the judge had to answer the simple question whether there was a contract. Because if there was a contract, then the claim of the salvors could only proceed on the basis of that contract. There would be no application of the law of salvage or the International Convention on Salvage 1989, which the UK is a party to, and which is scheduled to the Merchant Shipping Act, so part of UK law. So you see the crucial part. The crucial part of the communications are on that 26th of March 2021. That is 3 days prior to the completion of the refloating operation. You have two basically bits of the communications. To the left of the slide or the screen, you see a communication on behalf of the ship owners. So from the ship owners to the salvor or to the claimants, effectively going back to the salvors on their proposed contractual terms. So the proposed contractual terms had already been put forward by Smith International, and in that image to the left of the screen, which I know it's a bit hard to read, it says that basically the captain was writing to Smith saying, I'm pleased to confirm as below on behalf of the owners of the Evergreen the following. Those were the terms and the terms and conditions that were effectively being agreed upon by the owners. And Smith received this, and to the right of the screen, you see in the upper excerpt or screenshot, taken from actually one of the newsletters that commented on this judgment. You see that Smith was happy. They said, "Thank you, thank you, Captain, for conveying to us the agreement of your principles to the terms and conditions." Was this enough? Was this enough to constitute a contract, going back to the principles of salvage law? That's what the judge had to determine. And you see that the photo is taken actually from the judgment itself, in Bailey.org. So it was held by Justice Barker that surprisingly, perhaps after my narration, but it depends how I narrate it, right? No contract was formed. In fact, despite that kind of linear communication, the captain going back to Smith International and telling them, owners accept the following conditions, and Smith International responding by saying, thank you for that, it's pleasing news. The judge came to the view that this was not no contract had yet been formed. And why is that? The reason is because it was only one aspect of the contract. The contract, in fact, that sort of exchange only covered remuneration. Ultimately, it did not cover other aspects of the dealings of Smith as Salvor. That's one aspect, and another aspect is that the exchange did also specify that terms and conditions or contracts had still to be actually drafted, indeed. Whether that actually fits with precedent, we have in the third bullet on this screen, you find that there's the middle bullet paragraph. There was an attempt by owners to say that, well, it was a it was an emergency. So, and it's normal in emergencies that contracts are not drafted in detail, and that things are left for later to be formulated. And in fact, there was a precedent that they relied on to the effect that in those situations, a contract would have been deemed to have been made already. But the judge said that that is a question of fact. And in this case, the judge was convinced that no such consensus ad idem had been formed at that moment on the 26th of March. So that's what I wanted to share with you. I think I'll just add by saying that, as I said, the exchange of messages between the parties is damning more so on the owners, because it, in hindsight, they could have, if they were actually close, all that Smith International wanted is agreement on Lloyd's open form contract terms, and they were really pressing for the owners to agree to LOF, which is, and Lloyd's open form salvage agreement is a standard contract form, but it actually allows or provides that the claims of the contractor will be based in salvage law. So that's what the salvors wanted, or were trying to get out from the owners. They were not successful because, as I related earlier, the matter, the owners were very keen not to heighten their financial exposure. That's what was one consideration. Another consideration of the owners, and I think that goes to kind of give them a bit of, it's a bit, I think in all fairness to them, they were also concerned that because of the role of the Egyptian authorities, that is the Suez Canal Authority, they were apprehensive of involving a private salvor when they knew that the Suez Canal Authority tugs and vessels were effectively involved in trying to rescue the operation. So they were a bit torn between awarding an LOF contract, agreeing therefore to Smith's request, but at the same time not sure whether this would go down well with the Egyptian authorities, because the Egyptian authorities effectively in the canal were sovereign, and that is the word that they used. Let me just now move on to something else regarding the Ever Given, and this is also of concern, possibly. I don't know what you think about it. More than 2 years after the fact, the Flag State Authority, the Panama Maritime Authority issued its investigation report into the incident. There were elements in the report damning the crew apparently the crew or the owners of the Ever Given did not have some of the latest guidelines issued by the Suez Canal. They didn't have the latest version of it. But I think it was more the report of the Panamanian authorities. Again, it's the flag state. It was fundamentally pointing the fingers at the conduct of the pilots, the Egyptian pilots, who in the grip of the disaster, they were often not communicating in English, so they were keeping the the crew, out of the gist of what they were discussing. And they remember, as we heard in an earlier session, the pilots are kind of servants to the master. So it's the master that has to retains the command of the vessel. In another, I think, development, or some other developments that I want to quickly pass through, what is still pending in the Ever Given is that there's a general average act that was declared by the owners of the vessel, and that is, the adjustment of the general average act or losses are still underway. There was also a constitution of a fund in English jurisdictions by the owners. In February of this year, Maersk, which was completely alien or a third party to the incident, so 2 years after the fact, or less than 2 years after the fact, just in 2 years, they sued the ship owner, the Japanese ship owner, and the German manager of the Ever Given for delay caused to their vessels by the grounding of the Ever Given, because a host or a number of their vessels were delayed in there was a bottleneck of vessels trying to make it through the canal. I haven't yet been able to access the documents in the Danish courts on that. It will be very interesting to also see how that fans out. I think I did comment at Split that in the Egyptian courts, which I went through also in Arabic, these were there were proceedings brought by the Suez Canal Authority against the vessel, but they were settled out of court for a very high sum of money, but still under what was claimed by the Egyptian authorities. So enough perhaps on the Ever Given. For now, let me just tell you that we have a bit of a challenge now in salvage. As the Ever Given case demonstrated, some parties are not too keen to use the Lloyd's open form salvage. I think in the industry, it's now a known fact that there's something unpopular about the LOF. So it was amended, if I'm not mistaken, last year, but again, we are seeing some hesitancy about its acceptability. So there's ongoing discussion about the need to revise or to come up with a new solution. And I think it also ties with what we were discussing in terms of all the changes in ties in with the changes in maritime law. We are seeing new types of technology. It's no longer just oil-driven vessel, or oil-driven. There's also the fact that there are new players who are not necessarily all bowing to London markets or to the institutions like the International Salvage Union that drive forward this kind of terms and conditions. Now, then let me just move on quickly also to another part of casualty law, collision. There's an interesting case that was also handed down recently, just back in February of this year. Collision. Okay, this was the subject of our first day colloquium. In memory of a great professor of this city of Dubrovnik. So briefly, the facts of the case is that there were two vessels that collided, unfortunately, in the Chinese port of Tianjin. The names of the vessel are Sydney and Apollo, and initially when you read a judgment, you kind of look for prejudice in the names of the vessels, right? Do I like Sydney more than Apollo, or vice versa? So you can have your pick on that. I'll tell you the result later of the legal debate. There was a crossing situation. So a crossing is basically when it's not like a head-on collision, right? It's like almost like this or like this. You're crossing. Obviously, it's well defined in the collision regulations, which was not the subject of the colloquium on Monday. As on Monday, we just discussed the Collision Convention 1910. But what this case involves is really an interpretation of the collision regulations of 1976 or 72. Sorry, 72. According to the what was clear, and on this slide you actually have facts that were kind of agreed to. Apollo was the giveaway vessel. In a crossing situation, there's a rule, and you can see that in the snap or the screenshot that is the photo. According to regulation or rule number 15 of the collision regulations, the vessel which has the other on her starboard side shall keep out of the way and shall avoid crossing ahead of the vessel. So what was clear to the mind of the everyone involved in this case was that the Apollo was the vessel that had to give way. It was the giveaway vessel. It was the vessel that had to keep out of the way of the Sydney and avoid crossing ahead. But in fact, what Apollo did, it was the contrary. All right, so it actually did cross ahead of the Sydney and thus precipitated the collision. But it contended in its defense that, well, it was, they knew that they were going to have a crossing situation, but they felt that they could actually maneuver quickly to cross ahead of the Sydney. Okay, and the result of the judgment, and you see this in this kind of clipping from the press is actually the words that were uttered by the master of the Sydney when they saw what the Apollo was up to. So the Sir Nigel Tare, who was presiding the court, and he sat obviously with two assessors. He determined that the Apollo was entirely at fault, 100% at fault, because they clearly violated the rules that Rule 15 and 16, and it was no defense to the Apollo to say that they actually had communicated with the vessel, with the other vessel by VHF to tell them about what they are intended to do. So that was not a defense in law. Okay, so that was clear. That's the second bullet that you have on the slide. The other point is that this was not a head-on collision. So the Apollo did try to claim or argue that this was a head-on collision, and head-on collisions follow different rule of the collision regulations. According to the court, this was definitely not a head-on collision head-on crossing, because it did not comply with the rules. A head-on crossing is when you can see the side lights. Each vessel can see the side lights of the other. Also, why 100% liability? Because you could, if you were with us on Monday, remember that according to the rules of the Collision Convention 1910, liability is based on fault, and the degree of fault can vary. But still, the judge, with the help of the assessors, placed all the liability on the Apollo, because notwithstanding the fact that Sydney actually did increase a bit its speed and also changed its course in that hectic moment, and the justification of that was condoned by the judge is that they were obviously working up their engines, so it was normal for them to slightly increase their speed. And also, when they saw what Apollo was doing, they were also justified to change or alter their course. So in that respect, they were immune of liability under Regulation 17, which, if you go back to the earlier, Regulation 16. I'm sorry, there's an error in the last bullet paragraph. According to Regulation 16, every vessel which is directed to keep out of the shell so far. Okay, sorry, but I think I didn't actually. I don't seem to have Regulation 17 on the screen. Yeah, so this was that. I would want to perhaps just now comment on another development in relation to collision, and it's an interesting also new practice rule in the High Court that mandates the disclosure of navigational evidence by parties in a collision case. I think this is a new development for practitioners, which was kind of welcomed by the legal profession in London, because what it does, it lays out proactively all the evidence surrounding the navigational data. We talked about that, but I think it does have implications for burden of proof. I'm not sure that this actually ties or goes down well with issues of maybe fairness. Because, as you know, the rules regarding the burden of proof are centuries old, and they are designed in an adversarial court system like that of the UK. They are designed to kind of reward good lawyers' efforts. So maybe that sort of obligatory disclosure of data would work better in a non-adversarial court system like the ones we have in civil law countries. Nevertheless, this is a new court practice which can also have repercussions for non-collision cases. We spoke earlier about aspects, I think, of nautical error and how the evidence can be difficult to obtain by claimants in cargo cases. So this could actually set a precedent for other cases. Just to end here with two slides, I want to say sustainability. I think that before I touch on the Ever Given was definitely a case in point on the non-sustainability of the shipping industry, perhaps. I mean, one should say that these larger vessels are getting bigger and bigger, right? We know that. Is that sustainable? When we look at the sustainability 17 goals, the need to basically marry economics, social welfare, and the environment, it's not very clear that we're actually doing this by building ever bigger ships. There's just want to share with you the news about the largest cruise ship that will, and that also keeps getting bigger. It will be launched in October next month. It's being built in Finland, and it's already been trialed, I think. It will have over 7,000 people on board. So imagine the casualties that may arise from that. And it's basically, I've just captured one picture of it, which is the amusement park. It actually holds an amusement park on board. But you can look at you can scroll through the other pictures. They're just as breathtaking anyway. And my last slide is really on something really sad, which is the death by sea, which we're not really talking much about. Sustainability, I think, in terms of casualties, it's very important to talk about life salvage. And I think that the maritime community, I'm not just accusing the maritime industry, maritime community as a whole is kind of not being, not really up to the challenge of the boats carrying people. We have to call it, we have to be able to call it migration, because these people are effectively migrating. Whether that goes down well with immigration law or it doesn't, at the end of the day, these people are seeking a new life. But it's really now a course of not migration, but really death, and the safety or the unsustainability is at stake. We are discussing a lot of different aspects of the maritime industry in this course. What a fundamental one resides in safety, and I think we are not really, still not being or not us necessarily, but the stakeholders aren't able to, or they don't want to really tackle effectively this subject. And that's just obviously one headline out of many, because we're talking of scores and hundreds effectively. In 1 month, there can be hundreds of people dying by drowning or simply being lost at sea. So I hope I've been able to cover some aspects of the topic of casualties. Thank you very much.